And a proposed law to protect workers against discrimination in the workplace sets out 5 characteristics for safeguarding from a person's marital status to their caregiving responsibilities. And for a closer look at this issue, we speak next to Dr. Mathew Mathews, Head of Social Lab and Principal Research Fellow at the Institute of Policy Studies at NUS. Welcome to the show, Dr. Mathews. More action against discrimination at the workplace, but penalties are based on the severity of breach. How effective are they in tackling discrimination cases?
Well, they certainly can be effective. Penalties do deter organizations from engaging in discriminatory behavior, since it gives them a clear understanding of the consequence. You've got some kind of discrimination can lead to certain types of consequence. Perhaps it could be fines for the company. And that will certainly keep companies conscious about the fact that there are some actions which they need to steer clear from. And there's also, of course, a continuum of severity. So even when there are unintentional violations that do actually hurt people, then there are also some penalties. So overall, the picture is that things need to be done. But if you rely only on penalties, that may not create the kind of behavior change we want. We need a broader strategy as well that includes training, deeper cultural change. With all that together, you will be able to sustain some kind of behavior change.
And to see this change, the law is setting out 5 characteristics for safeguarding, which include age, nationality, and gender. And apparently they make up more than 95% of complaints today, according to authorities. Is coverage of the bill extensive enough?
The fact that 95% of the discrimination complaints that are received by agencies fall under these 5 protected characteristics does say that you can actually, with this law, deal with the great majority of these situations. I think that's good. But there's always going to be some areas where people feel that you need to make a firm stance against discrimination, areas such as sexual orientation, for instance. But it makes sense to start somewhere, and it's probably best to start with those where it's very, very clear that they are the areas where the most complaints come from.
There are exemptions. For now, firms with less than 25 staff are exempt, but this will be reviewed after 5 years. What do you make of this? Is the period of 5 years too long?
Well, hopefully there'll be interest to review this even sooner. But it's true that for companies to follow the expectation of any legislation on fair workplace practices, there is a burden of compliance measures. And this will be hard if you don't have the kind of size and dedicated types of human resource and other management personnel to be able to take care of these policies well. Nevertheless, we should hope that even small companies would make special effort to be trained to put in some of these policies to make their space a lot more inclusive, even without the burden of legislation.
And hiring and firing is by and large an employer's prerogative. Earlier you were talking about, why it needs to go beyond the penalties. Can legislation really make the difference here? Well,
it's true that legislation makes some amount of difference. You definitely, as an employer, you can make a decision to hire or fire. But ultimately, if that hiring and firing is stemmed from some kind of discriminatory principles or stereotypes about particular groups, or believes that some groups are not performing as well because of some kind of prejudices, then really legislation should signal to these employers there are some lines that they should not cross when they hire and fire. And certainly it should pertain to some of these protected characteristics.
We heard earlier, Dr. Mathews, from SNEF that companies probably need more time to prepare for the new law and that bigger companies are encouraged to take the lead here. What would an ideal grievance handling mechanism within a company need to look like in your view?
Well, one, it really has to be clear grievance handling mechanisms. So you're not guessing in terms of who you need to speak to, who you need to make the report to. There should also be good structures to make sure that confidentiality is preserved. So you don't have to fear that after you have made that complaint, your identity may be revealed, you may be subject to some kind of reprisals. There also should be that sense of fairness and accountability. We should know that I've put out a complaint. There are clear sets of measures as committees or groups or investigations that will happen. And if someone is something has been done wrong, then that person will be taken to task and there is some kind of clear penalty. All that needs to be clear to people. And I think that will help people to feel a bit more confident.
So it's a lot about trust.
Handling mechanisms.
It's a lot about trust, right, Dr. Mathews? How much can the law achieve if trust is broken between management and the staff?
Well, maybe that's why you probably need legal frameworks, because sometimes even when there is some kind of compromise, or rather the relationship of trust is broken between employees, they still have, and management, they still have recourse. They can look to legislation, they can look to some kind of tribunal outside their corporations to be able to deal with that. So legal frameworks do set the kinds of principles, the baseline of what is considered acceptable. But at the same token, we have to realize that if there is no trust, then people will always be second guessing what management may be interested in doing, whether there's going to be retaliation if they put out a complaint, and that might make the place not as inclusive as it should be.
All right, Dr. Mathews, appreciate your insights as always. Dr. Mathew Mathews there from IPS.